Good afternoon, everyone. We'd like to welcome you and thank you for joining our webinar, FMLA, Common Scenarios in Posting Obligations. A quick note before we get started. Please feel free to submit questions at any time during the presentation using the chat feature on your screen. We will respond immediately to any technical concerns, and we will try to answer as many questions as we can about the material presented via follow-up emails after the presentation. And without further ado, here is Ashley Kaplan, our in-house senior employment law attorney. Ashley has been practicing labor and employment law for more than 20 years, representing employers in a variety of matters, from discrimination and harassment litigation to defending FLSA class action lawsuits. Here at Poster Guard, Ashley handles our legal compliance and also oversees the teams responsible for researching all the posting laws and developing compliance solutions to meet our customers' diverse needs. As a special offer to our attendees today, Ashley will be available to set up a complimentary personal consultation about your specific posting compliance needs. If you are interested, please indicate that in the question box and we will contact you to set it up. And now, here's our presenter, Ashley Kaplan.
Thank you, and welcome everyone. The goal of today's webinar is to share some important information about the Family and Medical Leave Act, or the FMLA, and how posting compliance can affect your liability in an FMLA dispute. This is really an important topic because the FMLA is one of the most complicated employment laws for businesses to administer. Employers face a number of legal risks when managing FMLA, everything from determining an employee's initial eligibility to handling medical certifications and the communications with doctors and healthcare providers to disciplining an employee, either someone who's on leave or who has just returned from leave. And that's just assuming you're dealing with the FMLA alone. A lot of times you have to navigate through other requirements at the same time, like local, state or local family and medical leave laws, workers' comp laws, the Federal Americans with Disabilities Act that comes into play a lot with FMLA claims, and also your own company's leave policies. So understandably, a lot of you may feel like you're stuck in a legal maze with no relief in sight when it comes to this law, when it comes to the FMLA. So today, we're going to give you an overview of the FMLA, including common real-life scenarios and how to handle them. And we'll take a look at posting compliance and how it can impact you in an FMLA lawsuit or Department of Labor action. Most people actually think that the worst thing that can happen if you don't have up the right posters is a government fine. But we're going to take a closer look at the real dangers of noncompliance and how posting compliance can affect the outcome of your case if you are ever faced with a dispute under the FMLA. Okay, so first to give you some background on the FMLA. The FMLA is a federal law. It was enacted in 1993, and it was created specifically to protect workers from losing their jobs when they needed time off to address certain kinds of personal and family matters, primarily health-related issues. In 2008 and again in 2010, the FMLA was amended by the National Defense Authorization Act, and at that time it expanded the reach of the FMLA by granting leave benefits for employees with family in the military. These are the military caregiver rights you're probably familiar with, and we're going to touch on those later in the presentation. Regulations were issued by the Department of Labor in 2009 and again in 2013. Which, among other things, clarified employers' obligations to comply with the military caregiver provisions. And then finally, in 2015, the DOL issued new regulations revising the regulatory definition of spouse, recognizing same-sex marriages under the definition of spouse. And those regulations went into effect March 27th, 2015. So we're going to talk a little bit more about the impact of that as well when we get into the definition of family members under the FMLA. So the first thing that you need to know as an employer is whether the FMLA applies to your business. And it's not always so clear-cut. The FMLA applies to you if you have 50 or more employees on your payroll company-wide. And that includes part-timers and employees on leave, everyone on your payroll. If you're close to that number, if you're close to 50, the way to count it is to look at the current calendar year and the preceding calendar year, and you're covered by the FMLA if you have 50 or more employees on your payroll in at least 20 work weeks in either the current or preceding calendar year. And the weeks don't have to be consecutive. It's just the total that you're looking for. So also, a lot of people get confused and think you're only covered by the FMLA if you have 50 or more employees within a 75-mile radius. The 75-mile radius only comes into play when you're looking at a particular employee's eligibility, and we're going to get into that. But to be covered as a business, it's 50 or more employees company-wide. So even if you're at a smaller location with only a few employees, you are considered an FMLA covered employer if you have 50 or more company-wide. And this is really important because there are certain obligations you have as a covered employer, even if none of your employees will ever qualify for leave. It's mainly the posting and notification requirements, which are really important, and we're going to go over those in a moment. Also, the FMLA applies to public agencies, including state, local, and federal employers, and local education agencies, and that's regardless of the number of employees. So now let's talk about what kinds of absences are protected by the FMLA, and then we're going to cover employee eligibility requirements. So if you're a covered employer, you have to grant an eligible employee up to 12 work weeks of unpaid leave during a 12-month period for any of the following reasons: the birth and care of the employee's newborn child, the placement of a child with the employee for adoption or foster care, the care of an immediate family member with a serious health condition, or the employee's own serious health condition. And we're going to explore some of these definitions in a little more detail as we go. As I mentioned, the FMLA also grants additional leave to eligible employees who have covered family members in the military reserves, or also it applies to covered military veterans. And there are two categories of military family leave. First, there's the qualifying exigency family leave, which is also known as active duty leave. And this type of leave is for employees when they have an immediate family member with certain kinds of military obligations. And the immediate family member is defined as a spouse, parent, or child, and we're going to get into these definitions in a moment, like I said. For this type of leave, an employee can take time off for specific qualifying exigencies, and that's a term that is defined by the Department of Labor in the regulations. These are typically absences associated with things like attending official military events or celebrations. It also applies to an employee who needs to provide child care or attend a school-related event for a child of a covered military member. It covers absences due to appointments relating to financial or legal arrangements. Also absences to spend time with a covered service member who's on short-term rest leave. There are a few more under the definition, but again, it's any kind of qualifying exigency related to the service member's military obligations. Then there's another type of leave under the FMLA amendments, and this is the military caregiver leave. And caregiver leave permits an employee to take up to 26 weeks in a single year to care for a close family member who's been injured in the line of active duty. The 26 work week entitlement is a special provision, and obviously that extends FMLA job protected leave beyond the normal 12 weeks of leave. So it's always important to remember that this is the exception to the 12-week entitlement. Also, an eligible employee for this is defined as the spouse, son, daughter, parent, or next of kin of a covered service member. Okay, now we're going to go over the employee eligibility requirements. Who is entitled to take FMLA leave? To be eligible for FMLA protection, an employee has to meet 3 requirements, all 3. First, the employee has to have at least 12 months total of employment with your company. Now, this doesn't have to be a consecutive 12 months, so be sure to look back if someone has worked for you previously and come back to your company. You need to count that time. The regs do say that you don't have to count that time if there was a break in service of 7 years or longer, so you don't have to go back beyond 7 years. But be sure that you're taking a look at that before you deny someone time off under FMLA just because they haven't been there for 12 consecutive months. Next, the second requirement is the employee has to have been employed by your company for at least 1,250 hours of service during the 12-month period immediately preceding the commencement of the leave. So this means, so obviously that is consecutive. This means starting on the date that the employee needs time off, you would look back at the past 12 months and make sure they have worked a total of 1,250 hours. So if someone only works about 20 hours a week, they're probably not going to qualify. If their regular schedule is about 20 hours a week, that's not going to be enough. But always be sure to do the math, even with part-timers, to be sure. You know, there are fluctuations in hours and schedules change, and it's definitely worth it, and you need to do the math every time. Paid time off, like vacation or sick time, does not count when you're determining an employee's eligibility for this requirement. You don't have to count those hours. Finally, the third requirement is the employee has to work at a location where 50 or more employees are employed by your company within 75 miles of that work site. So if you have a small remote office that's part of a larger company, you may be a covered employer, but your employees may not be eligible to take leave because of this requirement. I've actually seen a lot of companies rely on this to their detriment, so be careful. You know, things change a lot, especially in large companies. So there might be mergers or acquisitions. You might have locations that are opening and closing around you. So make sure you think this through and look at it you know, every time before you rely on it to deny someone's request for leave. Okay, now let's talk about your responsibilities when you have an eligible employee who needs time off for any of the reasons that we've covered, any of the FMLA qualifying events. Very simply put, FMLA leave is just job-protected time off. And this means you can't terminate someone for missing work if it's covered by the FMLA. The FMLA does not require you to pay an employee's wage during leave. However, you do have to maintain any pre-existing group health insurance coverage for that employee. You cannot cut off their benefits. You have to maintain that. Also, job-protected leave means when the employee is ready to return to work, he or she has to be reinstated to his or her original position or to an equivalent position with equivalent pay, benefits, and other terms and conditions of employment, including substantially similar duties and responsibilities. We're going to talk about that a little bit more when we get into the scenarios. In addition, during FMLA qualifying absences, employees cannot be penalized for violating your attendance policy. These absences cannot count against an employee or result in any kind of discipline. Employees can choose, or in most jurisdictions, you can actually require this, to substitute accrued paid vacation or personal leave for any of the situations covered by the FMLA. So this means you would apply the employee's accrued paid time off to the FMLA leave period. So some, or in some cases all, of the leave would end up being paid because they're using their paid time off. In most jurisdictions, you can make this designation for your employee. It's your choice as the employer. But you would want to make sure that you've communicated about that in your employee handbook and your FMLA policy. And you need to make sure your employees are aware of your policy if that's what you're doing. And also, you need to make sure you're applying it consistently. If you're doing this, you need to apply it, in the same manner for all employees on all types of leave. Also, you would want to make sure that you're explaining that to the employee when you designate the leave as FMLA in your designation notice, which we're going to go over in a moment. That's the notice where you're letting them know all the details about their leave. You would want to indicate in that notice that if you are applying any kind of paid time that's been accrued to their leave period. Okay, know your state and local laws. I cannot stress enough how important this is. It's really important to go beyond the federal FMLA and become familiar with your state and local laws when it comes to family and medical leave. States are permitted to enact their own laws and regulations to provide even greater protection for their workers than are provided under federal law. So for example, there's a federal minimum wage, and then states and cities have the right to pass an even higher minimum wage, a higher minimum wage rate to give employees more generous terms of employment. So, and they often do. Most of the states have higher minimum wage rates than under federal law. And the same thing goes for the Family and Medical Leave Act. Most states do have their own versions of a family and medical leave law, and they are typically a lot more generous and broad than the FMLA. So this means you cannot just follow the FMLA. You have to know your state and local laws, and also whenever there's a conflict, you have to apply the specific parts of the laws that are the most beneficial to the employee. So, if some parts of federal law are more generous, you have to apply those. If some parts of the state law are more generous, you have to apply those together with the federal law. Here are some of the main differences to look out for, the ways that state and local laws typically differ or vary from the federal FMLA. First, they might apply to smaller employers. You might be covered, if you only have 20 employees, for example. It's not always 50. They might have less stringent requirements for employee eligibility. So you might have employees that are covered, with less seniority, or haven't been with your company that long, or even part-timers who work fewer hours than the 1250 required for FMLA. Some state and local laws provide for longer leave periods, even longer than 12 weeks. They might have a broader definition of serious health condition than under the FMLA. It might cover more types of health issues. They also might allow leave to care for individuals other than immediate family members, as the way that it's defined under the FMLA. And this is a big one. In some cases, the time off under state and local laws is considered paid leave. So you would have to pay the employee during their time off instead of, like under the FMLA, which is unpaid leave. And then finally, a lot of these laws provide employee leave rights for circumstances that go way beyond the scope of the FMLA. Things like parental leave for school activities, leave for organ donations, leave to give blood, and leave for a variety of other medical and family care activities. So you really need to look at that. Okay, other laws that commonly overlap with the FMLA are state workers' compensation laws and also the Federal Americans with Disabilities Act, or the ADA. If an employee is out for a workers' comp injury, don't forget that the FMLA may also apply. So you need to look at the illness or injury and then determine, as we're going to go through, is it a serious health condition under the FMLA? This is a common mistake I see a lot. A lot of businesses think that these laws are mutually exclusive. If someone's out on workers' comp, they don't need to think about FMLA. But that's not true. In fact, they often overlap, and employees are entitled to the protection of both laws simultaneously. So if the nature of the employee's workers' comp injury meets the FMLA's definition of serious health conditions, which we're about to go over, you need to designate any time off associated with that injury as FMLA time and follow all of the FMLA's provisions in terms of benefits, notices, and job restoration for up to 12 weeks. Anything on top of that that workers' comp law provides, you also need to provide that as well. Similarly, an employee who has a serious health condition under the FMLA might also qualify for accommodations under the Americans with Disabilities Act. So this means if the employee's health condition also meets the definition of a disability under the ADA, you might have to extend additional accommodations beyond 12 weeks of job-protected leave. So, the FMLA just provides for time off. The ADA can require, time off and then a lot of other accommodations. So it's something you need to be aware of. Also, the definition of disability under the ADA is pretty broad. So in a lot of cases, if someone has a serious health condition under the FMLA, it will probably qualify as a disability under the ADA too. I realize that's just a generality, but I am throwing that out there so you will always keep that in mind when an employee on FMLA asks for something more than just their FMLA time off, or if they ask for an extension. Just always consider it and go through the analysis. Accommodations under the ADA could include things like a reduced or modified schedule, light duty, a modified workstation or special equipment to help the employee perform the job, or it could even mean giving an employee an extended leave of absence beyond the 12 weeks required under the FMLA. So, an employee could use their 12 weeks of FMLA leave, and then, the doctor is letting you know, well, they need another 4 weeks for whatever reason. You need to look at that under the ADA and decide if that's a reasonable accommodation that your business needs to make. So under the ADA, you have to provide an accommodation as long as it is reasonable, which means you don't have to extend an accommodation if it presents what's known as an undue hardship to the business. And this is something that the law really kind of looks at on a case-by-case basis, and there are a lot of factors to take into consideration when you're determining, is this an undue hardship. The factors are, the size of your business, your financial resources, the cost of the accommodation, and most of all, the overall burden placed on the business and your workforce by the accommodation. But I would say, based on the number of ADA lawsuits that are filed nowadays, I would say it's a good idea to consult with an attorney before you decide to deny a reasonable accommodation or to let someone go, after FMLA when they're requesting more time. Just because you feel that an accommodation is not reasonable, it's it is a danger zone, and you should have a really good grasp on this or consult with an attorney before you're going to terminate someone or deny an accommodation request. So we keep talking about a serious health condition being one of the reasons that an employee can take FMLA leave, either because of the employee's own serious health condition or because the employee needs to help care for a family member with a serious health condition. The definition of a serious health condition under the FMLA includes an illness, injury, impairment, or physical or mental condition that involves either inpatient care, which is, in other words, an overnight stay in a hospital or hospice or residential care facility. So it has to either involve inpatient care or continuing treatment by a healthcare provider. And this is where it kind of gets gray and sticky. So continuing treatment is the more common of the scenario, and it can get tricky. I'm going to go through the way that it's defined in the regulations. The definitions are really long in the regulations, so I've tried to sum it up. But you can go to the Department of Labor website and read the exact definitions as this comes up if you're really stuck between one. But most of the time it ends up being pretty obvious once you get the medical certifications, and we're going to talk about that in a moment. Okay, so when we're talking about continuing treatment, it covers a lot of different scenarios. It generally includes, I'm going to go through a list, a period of incapacity of more than 3 consecutive full calendar days, and any subsequent treatment or period of incapacity that involves either treatment 2 or more times by a healthcare provider, and in that case it would need to be within 30 days of the first day of the incapacity, or it involves treatment by a healthcare provider on at least one occasion, which results in some kind of regimen of continuing treatment under the supervision of the healthcare provider. Next, continuing treatment also encompasses any period of incapacity due to pregnancy or prenatal care. Third, it covers any permanent or long-term condition requiring supervision by a healthcare professional for which treatment may not be effective. That's straight from the regs. Some examples for this category are Alzheimer's disease, severe stroke, or terminal stages of a disease. It also covers any period of incapacity or related treatment due to a chronic serious health condition. And there are very detailed definitions for each of these terms, including this one. But the examples for this category are, that the DOL provides are asthma, diabetes, or epilepsy. And then finally, it covers any absences to receive multiple treatments for restorative surgery after an accident or injury, or for a condition that would likely result in a period of incapacity of more than 3 days if left untreated. And the examples here are radiation treatment, dialysis, physical therapy, and chemotherapy. So just sort of guidelines to kind of help clear all this up. The DOL has provided some examples of conditions that typically do qualify as a serious health condition under the FMLA. And these are common ones that people have written in questions about, and that the DOL has heard come up a lot. And the examples are emphysema, appendicitis, severe respiratory conditions like chronic asthma, heart attacks, heart conditions requiring bypass or valve operations, back conditions requiring surgery or extensive therapy, most types of cancer, strokes, spinal injuries, severe arthritis, pneumonia, severe nervous disorders, any serious injury caused by an accident on or off the job, emotional distress following a miscarriage, and chronic migraine headaches. The DOL has also provided some examples of conditions that are generally not considered serious health conditions, so this might help by illustration. And of course there can be exceptions, but these conditions are generally not covered. The common cold, the flu, earaches or an ear infection, upset stomach, minor ulcers, headaches other than migraines, routine dental or orthodontia problems, periodontal disease, routine physical, eye, or dental exams, conditions that only require over-the-counter medications or that only require bed rest, drinking fluids, exercise, other activities that you can manage without going to see a healthcare provider. Cosmetic treatments, unless they require inpatient, overnight hospital care, or if there are complications that develop. And also food poisoning if it doesn't require inpatient or continued medical treatment. Another key definition to understand is family member and how it's defined for FMLA purposes. And this has evolved over time. So remember, one of the reasons an eligible employee can take leave is to care for a family member with a serious health condition. And family member under the FMLA is defined as a spouse, parent, son, or daughter. In March 2015, new FMLA regulations went into effect amending the definition of spouse, and this allowed an eligible employee to take FMLA leave to care for a same-sex spouse regardless of whether the employee lived in a state that recognized their marital status. Before that, eligible employees were allowed to take FMLA leave to care for a same-sex spouse only if they resided in a state that recognized same-sex marriages. So the regulations that became effective in March 2015 changed that, and so it was no longer a factor, is no longer important what state the couple resided in. As I'm sure that you all know, in June 2015, just a few months later, the Supreme Court of the United States made same-sex marriage lawful in all states nationwide. But at that point, the FMLA regs were already in place. The FMLA amendment had already taken effect. So the bottom line is that the definition of spouse under the FMLA covers all married couples, regardless of their sex or gender, regardless where they were married or where they live. All married couples are covered under the definition of spouse. The definition of parent under the FMLA includes the employee's biological parent or any individual, and that could be a grandparent or any other relative or person, any other individual who has stood in loco parentis to the employee as a minor. In loco parentis means the person had day-to-day responsibilities to care for and financially support the employee. So a biological or legal relationship is not necessary. It doesn't have to be a legal guardian even. So that could mean an employee could be entitled to FMLA leave to care for a step-parent or a grandparent or any other person if that person stood in loco parentis to the employee when the employee was a minor. But parents-in-law are specifically excluded, which makes sense. Son or daughter under the FMLA includes the employee's biological child, adopted child, foster child, stepchild, legal ward, or a child that the employee stands in loco parentis over. So the broad definition, this is a very broad definition because of the in loco parentis. The reason that it's so broad is it's intentional, and it's based on the reality that many children live with an adult other than their biological mother and father. So under the FMLA, an employee who actually has day-to-day responsibility for caring for a child and financial responsibility may be entitled to take leave even if the employee does not have a legal or biological relationship to the child. One little thing to be aware of, to take leave for a child, the child has to be under the age of 18. Or if they're 18 or older, then the child has to be incapable of self-care. And that's according to strict FMLA guidelines with definitions. So the person has to be, if they're 18 or older, they have to be incapable of self-care because of a mental or physical disability in order for an employee to take leave to care for them as their child. Okay, in some cases, your employees will ask for time off in large chunks of time, like 12 weeks for maternity leave, or 4 to 6 weeks for a surgery. However, in more and more cases, employees are asking for time off in smaller increments, like a few days here or there, or even a few hours here or there. And this is called intermittent leave. So this could mean, taking leave in short blocks of time as needed, as things come up for, whether it's flare-ups of a condition. It could be for appointments, follow-up treatments. A common one I see are, when things flare up like a back condition or severe asthma that, certain weather conditions might trigger. Assuming there's a serious health condition, as defined by the FMLA, of course there always has to be an underlying serious health condition. Intermittent leave may be used for medical appointments, like prenatal doctor visits or any doctor visits related to a serious health condition. It can be used for continual treatments, for things like chemotherapy or physical therapy or dialysis. And it can even be used for periods of severe morning sickness due to pregnancy. And these are just examples. A serious health condition might also require an employee to reduce his or her daily or weekly work schedule on a temporary basis. So this might be the case, for example, after an employee recovers from a condition or a procedure or some kind of serious surgery that leaves him or her 2 weeks to return to a full work schedule. There might be a need to kind of go to a reduced work schedule, and that the time missed would be counted as FMLA time. Intermittent leave is by far the most abused, and it can be tough for employers to administer. But in a moment, we're going to talk about your rights to get medical certifications and other things that you can do to stay on top of this. One thing to keep in mind that's helpful, when employees request intermittent leave or a reduced work schedule, you do have the right to ask them to try and schedule their time off so as not to disrupt business operations, like trying to schedule appointments near the beginning or the end of the employee's shift. If you want them to, if it is better for the company for them to be during a lunch break, whatever it is, so that it would have the least disruption to business. But of course, ultimately, that is subject to the approval of the employee's healthcare provider. If the appointments aren't available, or if certain visits or issues need to be taken care of at a certain time of day, you can't trump that. But of course, you can ask your employee to try to work with you and make appointments when they can be made, either before or after, or the beginning or the end of a shift. You can also assign an employee to an alternative position with the same pay and benefits to better accommodate the employee's intermittent leave or reduced schedule while they're on intermittent leave. That's also a possibility. Also, intermittent leave is something that you're required to provide when it comes to the employee's own serious health condition or the serious health condition of the employee's family member. But when it comes to FMLA leave for the birth and care of a newborn, for things like maternity leave, or for the placement of a child for adoption or in foster care, for bonding, you have discretion whether to grant or deny requests for intermittent leave. Your decision to approve or deny these kinds of requests can vary. It might depend on the employee's position, their department, their specific duties and scheduled hours, and you could look at the impact that those absences are going to have on the overall state of business operations. It's not always the same for everyone. But this is something you definitely would want to cover in your written FMLA policy. You want to cover, for bonding, new maternity leave and bonding, for example, whether intermittent leave is permitted, under the FMLA, or whether it's within management's discretion. Okay, now let's go over employee and employer notice requirements under the FMLA. The FMLA requires employees to give notice of their need to take FMLA leave. But be aware that employees don't have to refer specifically to the FMLA or to a legal right to take leave. And in reality, they rarely mention the FMLA when they're asking for time off, even if it's an obviously covered FMLA event like having a baby. They rarely mention the FMLA, and some people aren't even aware of it. However, they do have to provide enough information to let your company know that the FMLA might apply. And that could be something very simple, like just saying they need to take time off. They'd like to take some time off to stay home with their new baby, or they need some time. They need to adjust their schedule because their mom needs help. She's having surgery and she needs some help. That's enough to trigger your obligations. So it's up to you. It's your obligation as the employer to recognize the possibility that an employee's request for leave may be protected by the FMLA, and then to ask for more information if necessary to determine whether the law applies. And also remember, the employee's request does not have to be in writing to trigger your obligations under the FMLA. Most of the time it is verbal. So how much advance notice is the employer required to give you? If an employee's need for FMLA is foreseeable, like for example a non-emergency surgery or a scheduled C-section, then the employee has to give you at least 30 days notice. Employees who need leave for an unforeseeable reason have to give as much notice as is practicable. That's according to the regulations. And typically that would be the same or the next business day after the employee learns of the need for leave. I would be a little lenient here. I've seen some pretty bad cases where employers were a little too strict about not getting notice quickly enough and denying leave because it took the employee a few days. If there is a delay, try to find out the reason from the employee and then decide if it was reasonable under the circumstances before you deny a request just because it took a few days. It's just not worth it. Okay, now let's discuss the employer notice requirements under the FMLA, and then we're going to circle back to the process and the steps to take when an employee notifies you that they need time off. So a lot of employers overlook the FMLA notice requirements, and these notices are a critical part of FMLA compliance. The notice requirements are generally divided into 4 separate categories, and all of the notices are available from the Department of Labor, but you can also use your own versions as long as they comply with the regulations. And as we go through these and then circle back also to postings, you'll see why these are so critical. Just missing a certain notice can amount to what's called FMLA interference and trigger a lawsuit. So first, there's the general notice of FMLA rights and responsibilities. And this is a requirement that makes it mandatory for you to post a current notice that's issued by the Wage and Hour Division of the DOL, and it informs employees and applicants of their rights under the FMLA. This notice has to be posted in conspicuous locations throughout your business to ensure that it's readily accessible to all employees and applicants. And I read that straight from the regs, but basically what that just means is that you have to, in some cases if you have a large facility, you would have to post it in multiple locations just to make sure that it is readily accessible and it's something that all your employees would have access to and your applicants. So, in high traffic areas and break rooms, at an entrance if that's, how your applicants come in. If a significant portion of your workforce at a particular location is not proficient in English, then the law requires you to post this notice in the languages that they understand. And there's not a definition of significant portion. There are a lot of other laws and similar laws on a state and city level that go anywhere from 5% to 20%. So it really depends on how conservative your organization is, and how you look at compliance risks if you're not sure whether to post in foreign language. Also, this notice has to be also distributed to employees. So it needs to be posted, and then it needs to be distributed either as part of your employee handbook or as part of your orientation paperwork that you give to new hires on their first day. It doesn't have to be on the first day. I don't want to mislead you there, but it does have to be distributed. And that can be done electronically if that's how you communicate all your other employment policies and if you know that your employees have access to it electronically. By the way, this first notice requirement applies to all covered employers, so even if you have no eligible employees. So that means it applies to all employers with 50 or more employees company-wide, even if you're at a small location where none of your employees will meet that eligibility requirement of working in a facility with 50 or more employees within a 75-mile radius. You're still a covered employee and have to follow the general notices that we just went over. Next, there is the eligibility notice, and this has to be provided to employees who request FMLA leave. The notice must indicate whether the employee is eligible for leave. And those are the three basic eligibility requirements that we talked about. If the employee is not eligible, the notice has to state at least one of the reasons why not. So, you have to be specific. For example, you have not worked a total of 12 months with our organization. And this notice has to be provided within 5 business days after the employee's request. And don't worry, this form is drafted in a way that protects you if you still need more information from the employee's doctor to determine if there is a serious health condition. This form is just indicating whether the employee meets the basic eligibility requirements to take FMLA leave. You're not yet designating the leave as FMLA with this. In fact, this notice is actually where you let the employee know whether you're going to need a medical certification to make that determination. Okay, then there's a rights and responsibilities notice, which provides a variety of information about the FMLA and the terms of the FMLA leave, including things like whether you're going to require a medical certification or a fitness for duty certification, how payment of health care premiums would be handled, whether paid leave is going to be applied, like we mentioned. And this one also has to be given to the employee along with the eligibility notice within 5 days of the request for leave. So those should be given together. And then finally, there's the designation notice. And this one you have to give to your employees within 5 days after you received sufficient information to determine whether to grant leave. So we're going to talk about medical certifications that you can use to help you make that determination in a moment. But once an employee returns a medical certification to you, this is the notice that you have 5 days to provide. And this form states whether the leave is approved as FMLA leave and how much time is going to be designated as FMLA leave against the 12 weeks. And it also has other details, like whether you're going to require a return to work certification before the employee can be reinstated. So this is the actual designation that your time off is FMLA leave. These are the dates, and this is how we're tracking it. If your employee requests FMLA leave for his or her own serious health condition or for a family member's serious health condition, you have the right to request more information from the employee's healthcare provider to determine if the FMLA applies. And the best way to do this is by requesting the employee to get a completed medical certification from the healthcare provider. These medical certifications are available from the Department of Labor, similar to the notices we talked about, or you can use your own version as long as it's compliant. And there are different versions of medical certifications depending if it has to do with military caregiver leave, your own health condition, or a health condition of a family member. If you are requiring a medical certification, you need to give the employee the blank certification form within 5 days of their initial request for leave. So this should be given to the employee at the same time along with the eligibility notice and the rights and responsibility notice that we just talked about. So once you give the employee a blank medical certification, you have to give them at least 15 calendar days to return the completed paperwork to you. If you're not satisfied with an employee's certification, and this happens a lot, I get so many questions on this from clients. If you're not satisfied with an employee's certification, you have the right to contact the employee's healthcare provider directly to clarify or authenticate something in the certification form. I'm going to expand on that a little bit because this is important to understand. You have the right to contact the employee's healthcare provider, but first you have to give the employee 7 days, at least 7 days, to clear up any deficiencies on the form. So first give the employee a chance to go back to the doctor or do what they need to, get the information from the doctor on the form. A couple of things to keep in mind here when contacting a healthcare provider. Once you've given the 7 days, you can only go back to that employee. You can only go to that employee's healthcare provider about the form if you need to clarify or authenticate the form. Like maybe you can't read it, or maybe it's incomplete, or maybe it doesn't give you enough information to designate the condition under the FMLA. Also, you can only ask for information that is covered on the form itself. So, the form is very clear. It has, questions and blanks for the doctor. You can't stray away from that and ask anything else or anything more. So, you can't contact the doctor just because, maybe you disagree with the diagnosis or the recommended treatment, or maybe you suspect the employee is exaggerating a condition to qualify for FMLA leave. That's not what that contact is about. It's really about getting the form properly completed and getting all the information on the form clearly, and to have to authenticate it if maybe you don't believe that it came from that doctor's office. That's another reason you could contact them. If it's a case where you're really doubting the actual diagnosis or treatment or the need for leave, that's different. If you disagree that the employee even has a condition that qualifies as a serious health condition, you do have the right to request a second medical opinion from another healthcare provider, and that would be at your company's expense. Then if that opinion differs from the first, the employee can request a third opinion, but that's also at the company's expense. And the decision of that third neutral healthcare provider is final. It's considered final. So going back to the follow-up communications with an employee's doctor about a certification form, first, like I said, you need to give the employee a chance to resolve it. They have 7 days. If it's still not clear and you need to clarify or authenticate the document, you can contact the doctor. But you should always get the employee's authorization before doing so. Also, and this is very important, the person who's going to contact the employee's doctor should never be the employee's direct supervisor. To comply with the FMLA, the contact has to be made. It can only be initiated by an HR professional, a leave administrator, and that could include a third-party administrator, a management official, or another healthcare provider. So if you're going to go with an HR professional or a management official within your company, just make sure it is not the employee's direct supervisor. During an employee's leave, or if there's an extended intermittent leave schedule that's just going on and on, you also have the right to request periodic reports regarding the employee's status and intent to return to work. These reports can be in the form of a letter from your employee or the employee's healthcare provider, or you can even require your employee to call in periodically to confirm his or her status and intent to return to work. You can also require recertification in some cases, where you actually give a new medical certification and have the employee go get it completed and bring it back. For pregnancy-related absences or long-term conditions, you can request medical certifications every 30 days. For an extended leave that's been designated to last more than 30 days, where the minimum period of incapacity listed on the original certification form is more than 30 days, you can seek recertification every 6 months, and that's regardless of the stated duration of the condition. So if the doctor indicates that this condition is going to last 1 year, you still have the right to seek recertification every 6 months. You also have the right to seek recertification, to request a recert, if the employee requests an extension of leave, if it goes beyond the initial request, if the employee's or the employee's family member's health condition has changed, or if you receive new information that casts doubt on the current medical certification. Like maybe, the employee is on leave for back surgery, but, you find out that he's out there posting on social media that he's, on a cruise in Europe having the time of his life. That would be a circumstance where you would have received new information that cast a doubt on the current medical certification, and you could request a recertification. And believe me, people do this. I'm always surprised, but it is actually, unfortunately pretty common. So using all of these tools and knowing your rights and how to get medical information will really help you curb FMLA abuse. I've seen so many cases where an employee who is trying to abuse the system will really just give up. Maybe they're afraid that they've been busted or whatever it is, but they'll just kind of give up when they're questioned about an incomplete certification or asked to go back to the doctor, or when they're asked for a recertification when you've received any kind of news that things have changed or that maybe you suspect FMLA abuse. Okay, now let's look at some common workplace scenarios. And this is, we're going to apply what we've gone over so far, and also this will help us cover some twists that come up a lot. Let's start with Janet. So Janet in accounting has just informed you that she's pregnant with her first child. You discover that she knew she was pregnant during her job interview but didn't disclose it. She wants to know if she will get paid during maternity leave and whether you will hold her job open for 12 weeks while she's out. So, okay, let's assume for all of these scenarios that you are a covered employer under the FMLA. We're just going to assume that. In this scenario, this implies that Janet is a new employee since she was already pregnant during her job interview. So that implies that she's a fairly new employee. This means she probably doesn't qualify for job-protected FMLA leave because she probably wouldn't meet the eligibility requirement of having worked a total of 12 months for your company. There are exceptions. Like I said, if maybe she worked there previously within the last 7 years and came back, you of course would need to count that. But let's assume she's not eligible for FMLA leave. Is that the end of the discussion? No, it's not. So first of all, you would want to look at your state and local laws to see if there are pregnancy leave rights or family and medical leave laws that would apply to her situation. Like I said, in a lot of cases there are state and local laws right on point, especially for pregnancy and maternity leave. Also, be aware that the Federal Pregnancy Discrimination Act applies. And this applies to all applicants and employees. It's not a matter of how long you've worked for the employer. And the PDA, Pregnancy Discrimination Act, says that you have to, when it comes to maternity leave and leaves of absences, it says that you have to treat leaves of absence for pregnancies the same as you treat leaves of absence in general for other reasons. So if you have a policy that allows for medical leave or extended time off, you have to extend the same terms and benefits for pregnant employees asking for maternity leave. And you would need to treat the leave the same way as other leaves of absence. And that's everything from in terms of whether it's paid or unpaid, whether you have eligibility requirements. Your policy might say it's only available for an employee who's been here for 3 months. Also, whether you're holding the job open, if it's job protected, that it all depends on your leave policy, and you have to be consistent. Also, by the way, the fact that she didn't disclose her pregnancy during the interview is of no consequence. Employees, of course, have no obligation to share that. I threw that in because I get so many questions on that. Okay, next there's Frank, your warehouse coordinator, who's been with the company for 8 years. Frank mentions over lunch with a few managers that he is so tired from all the driving he's been doing, taking his son back and forth to physical therapy appointments after his car accident. His supervisor was part of the discussion, but it was his last week with the company, so he wasn't really concerned with Frank's attendance. He knew Frank was missing a lot of work, but he trusted that Frank would get his work done, so he didn't address it. A few weeks later, Frank's new supervisor, who just transferred in from another store, writes Frank up for excessive absences and demotes him to a part-time schedule with hourly pay. So the main point of this scenario is to underscore the importance of management training. Frank doesn't ever have to mention the FMLA to trigger his rights. And the fact that he told a few managers and his former supervisor, who was his supervisor at the time, why he's missing so much work, that would be enough to trigger the company's obligation to explore FMLA leave. And especially not to discipline him or terminate him or subject him to any kind of disciplinary action for his absences without further inquiry. In most jurisdictions, the company, an employer is deemed to have knowledge when its managers have knowledge. And that's huge. So, if a manager or a supervisor knows that there's an FMLA event, that's the same thing as your company having knowledge, and that's the case in most jurisdictions. So you really need to make sure that all your managers and supervisors are properly trained. They need to know how to recognize a potential FMLA qualifying event, and they need to know, your procedures. They need to know to escalate that to the proper individuals within HR whenever they learn of an employee's need for FMLA leave. So they're not just trying to handle this on their own, or maybe they're not even aware that caring for a son could have any kind of legal protections, caring for a child versus your own medical. It's not obvious to most people who haven't been trained on this. You should also include in your FMLA policy specific information on how employees should request time off in connection with health matters. You can put in there procedures to follow, like who to go to, how to ask for time off and who it needs to go to. So this will kind of help reduce the likelihood of this happening. So back to Frank, assuming that his absences were covered by the FMLA, which they probably were under these facts, he should not be subject to any kind of discipline or adverse treatment for his absences. Any kind of write-up that, he was demoted, he went to, hourly pay, so his, overall take-home is going to be much lower. This would be considered an interference with his FMLA rights and could subject the company to liability. Okay, next is Lisa. Your office manager, Lisa, has chronic back pain and starts missing a lot of work due to flare-ups. She is an eligible employee under the FMLA, so you provide her with the proper FMLA notices and a blank medical certification so you can determine if the time off qualifies for FMLA leave and how to designate the absences. She returns the medical certification on time. When reviewing the form, you see that under frequency, the doctor wrote unknown, and under duration, the doctor wrote indefinite. Should you designate her ongoing absences as FMLA qualifying? Okay, well, the condition itself probably does qualify as a serious health condition, but you have the right to request more information from the doctor on this one to determine the estimated frequency and the duration in order to properly designate the time off as FMLA qualifying. You have the right to get more information here. So you can ask Lisa to try to clear it up and give her 7 days. Have her go back to the doctor and try to get more specific information. And if you're still getting back the same vague information, you can go ahead and contact the doctor with Lisa's permission, of course, to get more clarification. And remember, when you're contacting the doctor, you're just sticking to the form itself. You're asking the doctor for, under frequency and duration for estimates. You need some kind of reasonable estimate. So, for example, the doctor needs to provide some kind of detail. It could even be, the flare-ups are estimated to occur 2 to 4 times per month under frequency. And for duration, it could be, this condition is expected to last at least 12 months. The point is, you don't have to settle when you get these certifications that are entirely open-ended and vague. You do have the right to get clearer information. And I'm seeing more and more of these coming in from doctors. So, follow up and get some more details. Finally, there's Bob, a sales associate, who is on FMLA leave for hip surgery. You have approved his leave, and he will be out for 6 weeks. While he is on leave, you discover in a routine audit that Bob was entering false sales to boost his commissions, essentially having items shipped to friends and returned once he was paid his commission. You discover that he was doing this for several months prior to his surgery and that he received hundreds of dollars in unearned commissions under this scam. Can you fire him even though he is on job-protected FMLA leave? The answer is absolutely. The FMLA prohibits you from terminating someone or retaliating against them in any manner for exercising their FMLA rights. However, this doesn't mean your hands are tied if there are other unrelated factors that warrant discipline or termination. You would just want to make sure that you have properly documented the basis for your decision. Of course, you need to document the legitimate business reason for your decision. And you'd want to make sure that you have all your ducks in a row in terms of getting the facts straight, doing a proper investigation, and any other fact finding that's reasonable to confirm the wrongdoing. Of course, there is always a risk with any kind of FMLA situation. There's always a risk that the person will try to turn it into a lawsuit. So you might want to consult with an attorney if you're in a situation where the basis for termination isn't as obvious or severe as the scenario I've given you here. In this scenario, there was a theft, and it was documented and established, and it's a little more clear-cut. But you do need to make sure you're basing any kind of disciplinary action on a legitimate business reason that has nothing to do with the person's health condition or need for FMLA leave. Okay, now let's shift gears and talk about FMLA enforcement and liability for FMLA violations. There are actually 2 ways someone can enforce their rights under the FMLA. An employee has the choice of filing a complaint with the Department of Labor or filing a private lawsuit. So this isn't like most discrimination claims where they have to go through a government agency first before going to court. A plaintiff can actually start, go straight to court with no administrative prerequisites under the FMLA. If an employee prevails, he or she can be awarded one or more of the following: wages, benefits, or other compensation that was lost, so that it could be back pay, for example. compensation for actual monetary loss, resulting from the violation, and that could include the cost of medical care up to a sum of 12 weeks of wages, interest at the prevailing rate. This one's important, double damages. These are liquidated damages that are, in an amount equal to all the damages that I just went over. The court can double them unless the court decides to reduce this amount because there was a showing that the violation was in good faith. The employer acted in good faith and had reasonable grounds for believing that there was not an FMLA violation. A person can also get equitable relief, which are, things basically putting them back in the position that they would have been in but for the violation. So, getting their job back if that's the case, getting their position back if they were demoted, reinstatement or promotion. And then also, which is a big one, attorney fees and costs. Now, posting compliance can have a significant impact on your liability in an FMLA case. And I'm going to explain how posters come into play in FMLA lawsuits in a moment. And posting compliance, of course, goes beyond the federal FMLA posting requirements. There are actually 5 other federal postings that you have to display. There are state posters. Depending on your city or county, there could be city-county posters. And then there are additional mandatory posters required for federal contractors and also employers in certain industries. So there are a few different ways that posting compliance comes into play with employee lawsuits. The first and probably the most significant, I think is the most significant from my experience, is when it comes to the statute of limitations. And the statute of limitations can be an employer's best friend because it's the defense that allows you to have a claim stricken or dismissed because it was filed too late. So, the statute of limitations, for example, for a federal discrimination claim in a lot of states is 300 days. And under the FMLA, it's 2 years. So typically, if you get a claim, a lawsuit from a former employee or even an existing employee for a violation that occurred outside of that time frame, you can move to have that claim dismissed and avoid all the legal fees and potential liability for the claims in the lawsuit. Even if there was a violation, you can move to have that dismissed because it was filed too late. However, if you have a posting violation, either a missing or outdated poster, courts have begun to publish more and more decisions saying that if an employee didn't have notice of their rights because the poster wasn't up, that the statute of limitations is extended or told. You cannot use it as a defense. So that means you could be forced to defend old claims that shouldn't even have gone to court. And we've seen cases that could have and should have been dismissed end up with a 6- or 7-figure judgment because of this. So it's really critical. Another way that posting compliance comes into play with employee lawsuits is as evidence of bad faith or good faith. So all the different employment laws have different standards where the concept of good faith or bad faith affects the employer's potential liability, where good faith can help reduce damages or bad faith can actually inflate your damages. So like under the FMLA, which we just saw, one of the damages that courts can impose are double damages or liquidated damages. That's also the case under the Fair Labor Standards Act for overtime or misclassification. You can be assessed double damages unless you can make a showing of good faith, and that's what we just looked at with the FMLA. So depending on the law at issue, courts look at a variety of factors to determine if a company acted in good faith or bad faith. Things like whether you had written policies in place, whether you trained your managers on compliance issues, what steps you took to prevent and respond to violations, how you updated your policies and notices when laws change. Now we're starting to see a lot more cases where posting compliance is coming in as a common factor that the courts are looking at when they're making these assessments. Also with the FMLA, specifically with the FMLA, the most recent regulations actually mention posting compliance as a recognized cause of action if a posting violation results in an interference with someone's rights. So failure to post the required notice, if it results in some kind of injury or harm. For example, if an employee didn't have the right information to know how long they had or what the procedures were for requesting a leave of absence or how to go about return to work or reinstatement, and they didn't have that information and that was caused by the absence of a posting, then the employer can be on the hook for any damages suffered by that employee under the FMLA. So, for example, if that employee was terminated, that could mean back pay, front pay, reinstatement, and so on. There are actually a lot of published cases where this has occurred. We actually have a detailed white paper with examples with, the case names and just, illustrations of how each of these concepts come into play. So if any of you are interested in reading more about the actual cases and the case law, just indicate that in the question box or send us an email, and we'll be happy to email that to you after the presentation. So needless to say, it's important to make sure you're on the right side of the law when it comes to posting compliance. It's simply not worth the risk to cut corners knowing these risks and the potential liability involved. It's just not worth it. Okay, well, that wraps it up. I hope you found this presentation to be helpful and informative. I know we went over a lot of legal requirements and details, but there's a lot to share when it comes to these laws and your obligations when it comes to posting compliance and staying on top of all these changes. If you have any questions or would like additional information about Poster Guard or any of the compliance issues I've talked about today, please feel free to contact our compliance specialist, Peter Frey, at 954-970-5702, or you can reach Peter by email at pfray, F-R-A-Y, @hrdirect.com. Thanks again for attending today's presentation, and we hope you have a wonderful afternoon.